There is a photograph I have never seen. I only know it from a letter. A woman standing at a window. Her daughter described it to me 8 months after the trial, just standing there in the morning light with her coffee, looking out at a backyard she had not been able to walk to for 2 years. That is the whole image. Woman, window, morning, coffee, backyard. That image is why I'm still talking about this case. Let me go back to the beginning. I have been a judge for 19 years. I have sat with murder. I have sat with fraud that ruined families. I have sat with choices that should never have been made. I thought I understood the shape of a medical negligence case: patient, provider, harm, standard of care, the math of loss. This case was not that shape, or it was that shape and then it became something else, something I am still finding words for now. I want to ask you something before I keep going. Have you ever been in a room where someone had the chance to protect themselves, to stay quiet, to let the system absorb what they did, and they chose the other thing instead? Not heroically, quietly. The way you choose something when you know it is going to cost you. Subscribe, because that choice is at the center of this story, and I need you here when we reach it. Her name was Marguerite Okafor. She was 53 years old. She walked into my courtroom on a Tuesday morning in March of 2023, and she sat down the way people sit when they have been carrying something heavy for a long time and have not decided yet whether to put it down. Her back was straight. Her hands were folded on the table. She wore a dark blue blazer that looked like a deliberate choice, like she had thought about this moment and decided she would meet it dressed for it. I noticed one thing about Marguerite during the proceedings that I have thought about many times since. When the evidence went hardest, when the scans were displayed, when the timeline was read aloud, when her own medical records detailed the months she had spent in a body that was not being correctly understood, she did not look away. She kept her eyes on the materials, not with anger, with the specific attention of someone who has already made peace with what they are about to hear and is there because the truth deserves a witness. That told me something about who she was choosing to be inside this situation. I carried that. His name was Dr. Leonard Fass. He was 61 years old. He had been a radiologist for 32 years. When he walked into that courtroom, he looked like a man who had not slept well since October of 2021, which, as it turned out, was almost exactly when this case began. He sat carefully. He arranged his papers. He did his best to look composed. He did not fully succeed, and I do not say that as a judgment. I say it because it was the first honest thing I saw from him. There was a moment during the second day, not related to the charges, when a younger attorney made a small procedural mistake and looked mortified. Leonard Fass looked over at that attorney with something in his face that was not contempt. It was recognition. The face of someone who knows what it is to have made a mistake in a professional room. I noticed it. And then I had to sit with what that noticing required of me, which was to see him fully the same way I was seeing Marguerite, before I ruled on either of them. Here is what happened. On October 14, 2021, at 9:47 in the morning, at Saddleback Regional Medical Imaging Center in Lake Forest, California, Marguerite Okafor underwent a CT scan of her thoracic and abdominal region. She had been referred after 3 months of increasing back pain and 11 pounds of unexplained weight loss. Her physician's referral noted that the symptom combination warranted prompt imaging and review. Dr. Leonard Fass read that scan at 2:15 that afternoon. He filed his report at 3:08 p.m. The report noted mild degenerative changes and muscle strain. It recommended conservative management and a follow-up in 6 months. What it did not note was a 2.3-centimeter adrenal mass visible in the upper left quadrant, a mass that a second radiologist, Dr. Elaine Chun, identified 5 days later after being flagged by a technician with concerns. Dr. Chun filed a formal correction request on October 19th, marking it urgent. She sent Dr. Fass a direct message at 4:45 p.m. that read, "Leonard, scan from Thursday Okafor, M. There is an adrenal finding I believe warrants flagging. Please review my notes. This needs an addendum." Dr. Fass read that message at 6:02 p.m. There is a timestamp proving it. He did not file an addendum. He did not contact Marguerite's physician. He did not respond to Dr. Chun. The 6-month follow-up was never escalated. Marguerite Okafor was not told a correction had been sought. And for 17 months, the mass grew. She was diagnosed with adrenal cortical carcinoma in March of 2023, stage 3, surgery in April. Prognosis at time of trial, guarded. He said from the witness stand, when asked why he had not responded, "I thought it was a difference of interpretation. I thought I had been thorough." He said it without looking away. That was the sorrow current, speaking plainly. If you are still with me right now, you have probably gone quiet. Whatever was in the background of your life a few minutes ago has probably faded. Subscribe. That kind of attention deserves the rest of this story. Subscribe and turn on notifications. The case file arrived on my desk 4.3 inches thick. I measured it. There were 847 pages, medical records, imaging reports, internal communications, expert depositions, procedural documentation. I read all of it over 3 days. I read Dr. Chun's correction request 4 times because I wanted to understand not just what it said, but what it cost her to send it. For viewers who are not medical or legal professionals, when one radiologist identifies a material discrepancy in a colleague's report, they have both a clinical and ethical obligation to document that discrepancy formally and ensure it reaches the ordering physician. This is not a courtesy. It is a standard. A radiologist who receives a peer correction request and does not file the required addendum is not exercising professional judgment. They are failing a patient. The moment in the legal process where both rivers were present at exactly the same time was the moment I read the timestamp, 6:02 p.m., 14 months before diagnosis. I felt the full weight of everything that happened after that number and also something else. A question about what he was carrying in that moment, what he was afraid of. Those 2 things did not reduce the harm, they just made the full shape of it visible. I named that to myself and moved on. Here is what I am offering, the rest of this story, told the same way I have been telling it. Nothing held back, nothing resolved before it should be, nothing softened because it is easier that way. Subscribe if that is what you want. I will keep going. Marguerite Okafor entered my courtroom on the first day of testimony at 8:51 a.m. She came through the side door, walked past the gallery without looking at it, set her bag down, and took out a legal pad and a pen, not a phone, a pen, and placed them in front of her with the care of someone who had decided this proceeding would receive her full presence. From the bench I could see both her face and the defendant's table. When she placed that legal pad down, Dr. Fast looked at it, just for a second, and something moved across his face. Not guilt exactly, not relief. The face of someone who had understood, for the first time, the full weight of what this woman had prepared herself to carry into this room. That moment sat exactly between the 2 rivers, neither purely sorrowful nor purely hopeful, both from where I was sitting. The sorrow current in this case ran clear from the beginning. The first piece of evidence that established the full weight of what was lost was Marguerite Okafor's surgical report from April of 2023. The tumor had grown from 2.3 centimeters to 7.8 centimeters at time of resection, 1 adrenal gland removed, a left kidney partially resected, ongoing oncological surveillance required for the remainder of her life, 17 months of growth that the evidence documented with precision. I did not try to soften it. The sorrow current needed no help from me. From her victim impact statement on the 3rd day, I spent 2 years being told I had a muscle problem. I did yoga for a muscle problem. I went to physical therapy for a muscle problem. I was 53 years old and I thought I was falling apart. I did not know I was being failed. I wrote that down. That was the sorrow current at full strength. Then the grace current arrived through the door I did not expect. On the 2nd day of proceedings, Dr. Elaine Chun testified. She was 54, precise, visibly nervous. She said, "When Leonard didn't respond, I thought maybe I had been wrong. I second-guessed myself for 6 months. I still have the message I drafted to send again and never sent. I should have sent it. I am sorry I didn't. I have to carry that." She was not a party to this case. Nobody required her to apologize. Nobody asked for her hesitation. She named it because it was true. That is the specific quality of something that earns its place in a story. The two currents moved toward each other through the following days. Both rivers ran through the same piece of evidence at the same time for the first time when Dr. Fass's internal communications were entered into the record, a series of emails he had sent to the Imaging Center's Quality Review Committee in November and December of 2021, 2 months after reading Marguerite's scan. In those emails, he had flagged concerns about peer review protocols. He wanted clearer communication channels. He was trying to fix the system. He sent those emails while Marguerite Okafor's uncorrected report remained in her file. The sorrow is plain, but those emails also told me something, that he had known something was wrong, that he had felt the gap and reached toward it in the wrong direction. He had tried to fix the process instead of fixing what the process had failed to catch, both things in the same evidence. A nurse practitioner from the imaging center said in her testimony, "The thing about those emails is that he was right about the protocols being unclear, and that doesn't change anything for Marguerite. Both things are true. He knew something needed fixing. He fixed it in the wrong order." I wrote that down. That witness was standing at the confluence without knowing it. I just realized, saying this out loud, that I have never described those emails and that uncorrected report in the same breath before today. I have always separated them. Saying them together just changed the shape of this case inside me again. Subscribe. That shape is what the sentencing was built on, and you need to be here for it. Subscribe now. The defense argued competent professional judgment. They argued that radiological interpretation involves a spectrum of assessment, that the peer review system had failed rather than one physician, that 17 months between scan and diagnosis could not be attributed solely to the missed finding. Those arguments were made carefully and not in bad faith. The moment the defense said something that surprised me, not strategically but humanly, came during closing argument. The lead attorney said, "Dr. Fass has spent every day of the past 18 months asking himself what he should have done differently. That question is real. It does not constitute a verdict, but it is real. The man who made a mistake and the man who has been living with that mistake are not separate people. They are the same person, and that matters." I wrote that down too. It belonged to the grace current, not because it resolved anything, because it was honest. What the defense could not resolve was the read receipt, 6:02 p.m., a message marked urgent, opened and not answered. That required acknowledgement from a direction that argument alone could not provide. Then the defendant's own testimony. At the end of his direct examination, in a voice quieter than it had been for the previous hour, Dr. Fass said, "I knew what the message was going to say before I opened it. I had already looked at the scan again, and I still didn't file the addendum. I don't have a good answer for why. I think I was protecting something that didn't deserve to be protected." I wrote it down. I looked at it for a long time. The sorrow of a choice that cost someone 17 months was in that sentence, and so was something else. A man saying in a room full of consequences that the thing he protected did not deserve protecting. Both things in one sentence. I did not expect that. I want to stop here for just a moment, not for effect, because what he said from that stand, that the thing he protected didn't deserve protecting, is something I have heard very rarely in 19 years. I needed to say that plainly before moving forward. Subscribe while I sit with that. Subscribe and stay. Okay, let me keep going. My father had a small auto repair shop in Fresno. In 1987, he received a letter from a customer saying he had installed a brake component incorrectly and that the customer had nearly been in an accident. My father called the customer. He fixed the car. He refunded 6 months of service. He also told 3 neighboring shops about this specific part failure so they could check their own records. He lost some business. He told me later that losing that business felt like the right weight to carry, that carrying the right weight was different from being crushed. He said, "The mistake was going to live somewhere. I chose to let it live in the right place." I set that memory next to this case without explaining why. The viewer will feel where it belongs. Before I read the sentence, I want to tell you what the room looked like from the bench. Marguerite Okafor was seated and still. Dr. Fass was seated and still. The gallery was quiet in the way galleries are quiet when everyone has decided to be present. My hands were flat on my notes. I had been writing this ruling for 11 days. 3 versions. The one I was about to read was the one that held both rivers. The other 2 had held only one at a time, and neither was enough. I had decided carefully. I had decided knowing this ruling had to hold the weight of what was lost and also leave room for what might still happen. Those 2 things do not always fit in the same ruling. In this case, I had made sure they did. The verdict was for the plaintiff. The finding of negligence was clear. What I had to decide was what the response looked like, what form accountability took when it had to carry both the damage and the possibility at the same time. Marguerite Okafor's daughter made a sound when I read the verdict, not a cry, one exhalation, the kind that comes from carrying something for a very long time and being told you may set it down for a moment. That is all I will say about that. Here is what I ordered. I am ordering compensatory damages in the amount of $2.1 million to Marguerite Okafor directly, designated for ongoing medical care, surgical follow-up, oncological surveillance projected over 20 years, and professional income she could not generate during recovery. That money is not a replacement for what was lost. Nothing is. It is a structure. The court saying, your body deserved to be known accurately, and since it was not, the resources to care for it correctly will be provided. I am also ordering Dr. Leonard Fass to complete 600 hours of direct service to Saddleback Regional Medical Center's Patient Advocacy Office over the next 3 years, working in the office that receives complaints about imaging and diagnostic review, sitting alongside patient advocates as peer correction requests come in, and contributing to the redesign of the peer review communication protocol that he himself had begun flagging in those 2021 committee emails. He will not sit above that process. He will work inside it. The skills that made him a radiologist for 32 years belong to patients. They will be directed toward ensuring that what happened to Marguerite Okafor cannot happen through the same gap again. I am also ordering mandatory enrollment in a medical ethics and clinical accountability program through the University of California system, 18 months, with quarterly reporting to this court. This is not remedial, it is structural. What the evidence revealed was not that Dr. Fass lacked skill. It revealed that he lacked a framework for what to do when protecting his professional standing came into direct conflict with protecting a patient. That framework exists. He will build it. And there is one more thing. I am ordering Dr. Fass to write a letter, not to the court, not to his attorneys, but to Marguerite Okafor. Not an apology designed to satisfy a legal requirement. A letter that addresses, in his own words, what he understands about the 17 months between October 2021 and March 2023 and what he believes she deserved from the moment that scan crossed his desk. She does not have to receive it if she does not want to. That choice belongs entirely to her. He has to write it. That is the door. What he does with what is on the other side of writing it is between him and the rest of his life. If Dr. Fass completes the service hours and the ethics program 18 months early and submits a progress report demonstrating sustained documented engagement, not compliance, engagement, the court will consider a reduction in the structured reporting period. That condition is my way of saying something I could not say as a sentence. I believe he is capable of the attention this case required because I watched him give that attention to his own culpability on the stand and he did not look away. You just heard what I ordered in that courtroom. I want you to hold that. Subscribe before we go further. Because what happened after I spoke is the part I have thought about most. Subscribe now. Here is what I said to Leonard Fass directly. What you did, the specific choice you made at 6:02 p.m. on October 19, 2021, when you read a message marked urgent and closed it without acting, is not reducible to system failure or interpretive difference. You were the system at that moment. You were the last person standing between a missed finding and a patient, and you stepped aside. For Marguerite Okafor, and for every person who sits in the imaging chair trusting that their scan will be read with the full weight of attention it deserves, the court names what you lost. It is real. It is documented. It cannot be given back. What this court can do is insist that the record of it live in the right place. For Leonard Fass, you said from the witness stand that the thing you protected did not deserve to be protected. I believe you meant that. The question the rest of your career now answers is whether a man who knows that can become someone whose work is built on it. For everyone in this room, we are all, at some point, the last person standing between a failure and someone who cannot protect themselves from it. What we do in that moment is the most specific thing about us. And here is a fact. In the 16 months between the filing of this case and the verdict, Saddleback Regional implemented a new peer review escalation protocol requiring a 48-hour acknowledgement window for all urgent correction requests, with automatic supervisor notification at hour 25 if acknowledgement has not been received. That protocol is now standard. It was built in part from the emails Leonard Fass sent in November and December of 2021. The system he wanted to fix got fixed, in the wrong order, with the wrong cost, but it got fixed. The court holds both things. The courtroom emptied slowly. I stayed at the bench. Marguerite Okafor gathered her legal pad, the one she had carried in on the first day. Her attorney said something. She nodded once, slowly, the way you nod when you have heard something true that you were not sure you would hear in this room. She and her daughter walked toward the exit together without hurrying. Her daughter reached out and touched her mother's arm just at the elbow for a second as they walked. Dr. Fass remained seated after his attorney stood. He reached into his jacket and took out a folded piece of paper. He unfolded it and looked at it for a long time. I could not see what it was from the bench. I picked up my pen and wrote down the time, 11:43 a.m. I don't know why I wrote it. I wrote it. Then I stood. On November 7, 2023, 7 months after the verdict, I received a copy of a letter forwarded to the court by Marguerite Okafor's attorney with her permission. It was from Dr. Leonard Fass, 4 pages, not a legal document. A letter from one person to another about the 17 months between an unread message and a diagnosis. The attorney noted that Marguerite had read it twice and placed it in a drawer. She did not say which drawer. She did not say anything else. Both rivers are in that description. The sorrow of what required the letter to be written. The grace of what required her to read it twice before deciding where to keep it. The case was appealed in June of 2023 on grounds related to damages calculation. The California Court of Appeal, 4th Appellate District, affirmed the ruling in full in February of 2024, 8 months. When I heard the affirmation, I was between hearings. I sat with it for a moment. It felt like being confirmed in something I had already decided, a specific kind of quiet that is different from being right and warmer than relief. This case showed me something I am still working out. I thought accountability was a correction, a response applied to a deviation. What this case showed me is that accountability is a continuation. It is not what happens after the wrong. It is the process by which the wrong becomes part of what you build next, and whether you carry that weight in a place where it can be useful. I have watched people do both in my courtroom. What distinguished them was not how much they felt, it was what they did with the weight after the room emptied. I have not said that in any professional context before today. This case produced it in me. No other case had. To anyone who recognizes the weight Marguerite carried, who has trusted a system with their body and been failed by the person who was supposed to be paying attention, what I saw in her was that her dignity in that room was not something the failure could reach. She brought it in. She kept it. The sorrow did not erase it. I watched that happen from the bench, and I am telling you because I was there. To anyone who recognizes the chair Leonard Fass sat in, who made a real choice that caused real harm, and is now carrying the question of what comes next. The people I watched move towards something were not the ones who felt the most remorse. They were the ones who took the weight of the wrong and put it somewhere it could be useful. They became part of the repair, not because a court required it, because they understood that the only honest response to having looked away is to spend the rest of your working life looking directly. Subscribe and stay, that is all. There is a photograph I have never seen. A woman at a window, morning light, coffee, a backyard she had not been able to stand in for 2 years. Her daughter said she just stood there, not doing anything, just standing in the light coming through the glass. That is why I told you this story. Subscribe, and if you leave something in the comments, leave not just what you felt, but what you are going to do with it. That is the room I want to build down there. The one where people willing to feel two things at once find each other and say so.